In the second day that Obama was in office, he announced a new initiative on open government and strengthening the Freedom of Information Act. And I was at a White House meeting yesterday on how to implement that. He's clearly moving forward in such areas regarding torture and Guantanamo. This is a complicated area. And as you said, I mean, it's unfortunate, of course, but Congress did some things in the last session which are certainly a setback. But I wouldn't give up on this one. I think this is an area where people, in both parties understand the need for some accountability. Otherwise, it becomes very difficult. It becomes very difficult for the United States to take a strong stand on rule of law issues around the world.
Just to underline that, I don't think most ordinary Americans understand that it's not that tough to refer someone for criminal prosecution. And both, I believe Tom Tam has been criminally investigated. I have been criminally investigated for my conduct. I have also been referred to the state bars and am still under investigation after more than 5 years. So the fact that there's all this hand-wringing over, if anything, maybe the people who wrote some of these controversial memos might be referred to state bar disciplinary authorities, and that criminal referrals are completely off the table, just boggles my mind, and I just find it hideous. In terms of the OLC memos, I wanted to ask the panelists, I know there's a policy that Obama and Holder have expressed towards openness, and I know last week they released 9 of the memos, and you've talked about, one of you talked about your favorite memo being the one by Stephen Bradbury saying, oh yeah, everything we did was probably illegal, so we're just gonna, it was in the heat and the fog of war and the heat of 9/11 that we did this. My favorite memo so far that's come to light is this one by John Yoo, my classmate at Yale Law School, on the constitutionality of amending the Foreign Intelligence Surveillance Act to change the purpose standard for searches. This sounds like a bunch of gibberish to everybody, but basically, under the old FISA law, it had to be a primary purpose. Foreign intelligence investigation had to be a primary purpose to not have to go through the normal warrant procedure. Then the Patriot Act watered that down to a significant purpose. But only last week we learned that John Yoo, if he had his way, he would have just had it be a purpose. A purpose. We believe that changing FISA's requirement that the purpose of a FISA search to collect foreign intelligence to a purpose will not violate the Constitution. A purpose can be anything. Anything. And in terms of what Wes talked about, the snowball effect, I think of how I was made the target of a criminal investigation after being called a terrorist, a turncoat, a terrorist sympathizer in the New York Times, and how that snowballed into a criminal investigation, and how that snowballed into being put on the no-fly list. And it's hard to put the toothpaste back in the tube after you smear somebody like myself, like Tom, and hundreds of other people who are at the conference this week. So I know selectively they're releasing OLC memos, but still, of the 9 that were released last week, they were not among the most controversial that dealt with torture, and the most controversial that dealt with the justification for domestic surveillance. So I'm wondering what everybody on the panel thinks is the likelihood that the more incendiary of the memos will be released.
Well, I mean, in our case, we have 10 memos are in dispute right now, and you can look on our website at epic.org. You can see the motion that we filed with Judge Kennedy here in the district court in Washington last Friday, essentially bringing to his attention, we did it as a notice, not as, there's an in-camera review right now, which means the judge is actually reviewing the documents. He's rejected government's motion for summary judgment, which is good for us, actually. But in the course of the in-camera review, which is his determination as to whether the government properly asserted its exemptions, its reasons for withholding information, we wanted him to be aware of Holder's announcement. We wanted him to be aware of the Bradbury memo. We wanted him to be aware of Senator Leahy's statement in support of the release of the OLC memo, and we wanted him to be aware of the President's statement on openness in government. Now, we think all of those factors are favorable with respect to our pending request that these 10 OLC memos be released. So that's where we are right now on that case.
Yeah, I'll say I've got a list here of about 50 some odd OLC memos that we're looking to have released, and about a dozen of them are out there in one form or another, some of them heavily redacted. I think it's worth making the positive point that if there's one thing that the President seems to have been committed to during the campaign, during the transition period, and early in his administration, is this notion of transparency. Everything that got submitted to the transition office was popped up on their website and made available. And I think the release of these few memos here in the beginning is a good sign. And I am sure that others will come out. It's just going to be a question of whether it's through the administration's efforts, their policymaking efforts, or through litigation. I think they'll come out at some point.
I agree. If anyone wants to actually see the memos, again, ProPublica, an internet news organization that's doing investigative journalism, has a centralized website with a list of the approximately 52 memos of which we are aware. And the ones, the dozen or so that are public, there are links to the various groups that have been able to get those made public, so you can view them there. In conclusion, I would just ask what your recommendations are that in terms of what ordinary citizens can do and interest groups can take regarding FISA, which was not a household word until maybe a year or two ago when they actually started to talk about very publicly amending the FISA bill, and suddenly there were ads taken out in the New York Times and Washington Post against telecom immunity, and people who didn't know what this obscure FISA was became more attuned to it. But if there's specific things that if you're not a member, if you're not part of the ACLU, if you're just a regular person, what can you do? What would you recommend?
Well, I'd say, of course, visit our website, because a lot of what we do is to try to inform the public about these issues and how these changes impact their rights. But I'd also just point out, to put this all in context, until the Patriot Act, until national security letters, until the warrantless wiretapping program, many of us thought that the real need in the United States was to reform the FISA to make it more accountable, because that law pre-9/11 relied on a secret court, permitted the issuance of secret warrants, had very little public accountability, and it was essentially a rubber stamp court. I mean, there were something like 30,000 FISA applications going back to 1978, maybe a couple of dozen. I mean, Tom would know the actual numbers, but he knows what the problem I'm describing, which is not to say that people in his position didn't take their responsibility very seriously. I think they do take the responsibility seriously. But if you go back to the 1968 law, and this is really what I want to say, I think in 1968, when Congress authorized electronic surveillance in the United States to make it possible to gather evidence this way and use it in criminal proceedings, they described it as an investigative method of last resort. And they built an extraordinary range of safeguards: judicial oversight, public reporting, the cost, how much of the communication was incriminating, how much was not. It was a really brilliant law. Not that I'm in favor of electronic surveillance, but if you're going to permit it, you do it under the kind of regime that was created in '68. To understand how far we've gone to the current day, I think you need to go back to '68 and understand what a real law would look like that would provide for oversight and accountability.